on absolute immunity for judges and magistrates. You got the Supreme Court case Mireles v. Waco. Mireles v. Waco, 1991, said that there are two ways that a judge could be held to a 42 U.S. 1983 claim. The judge's action was non-judicial, or two, the judge acted outside of his or her jurisdiction. Justice Stevens dissented in Mireles, 1991, declaring that a judge is non-judicial when he or she orders a cop to commit battery. The events behind Mireles is that Judge Raymond Mireles ordered some cops to bring Mr. Howard Waco, the public defender, into the courtroom for his morning calendar hearing and ordered the cops to use excessive force. The officers allegedly, by means of unreasonable force and violence, seized plaintiff and removed him backwards from another courtroom where he was waiting to appear, cursed him, called him vulgar and offensive names, and then without necessity slammed him through the doors and swinging gates into Judge Mireles' courtroom. Mireles, 1991, quoted Bradley, 1871. Although unfairness and injustice to a litigant may result on occasion, it is a general principle of the highest importance to the proper administration of justice that a judicial officer, in exercising the authority invested in him, shall be free to act upon his own convictions without apprehension of personal consequences to himself. In Bradley v. Fisher, 1871, we learned that a probate judge, a judge who presides over settling the estate of a dead person, has no business conducting a criminal trial, since a probate judge has no jurisdiction over the subject matter of crime. Justice Davis dissented in Bradley v. Fisher, 1871, proclaiming that when a judge has acted maliciously and corruptly, then he, she, too, should be subject to suit as a private person would be in Re 42 U.S. Section 1983. Lawyer Joseph H. Bradley lost his temper, chastising and remonstrating Judge George P. Fisher in the strongest of terms, because Lawyer Bradley had felt like Judge Fisher had insulted him a bunch of times during the course of the trial and proceedings. In retaliation for Mr. Bradley's outburst, Judge Fisher banned Lawyer Bradley from ever practicing law in that courtroom ever again. The subject matter of Bradley v. Fisher, 1871, had to do with the assassination of Abraham Lincoln. Most of Lincoln's assassinations and collaborators were gunned down or hung, including Surratt's mother, but John H. Surratt Jr., a suspected conspirator, had absconded to Canada, and then to England, and then to Italy, and then to Egypt, where U.S. authorities finally arrested him. The holding of Ex Parte Milligan, 1866, forced a civilian court to try the case over a military court in 1867, and therefore John Surratt Jr. was tried. John H. Surratt Jr. was tried in a civilian court. Now, Judge George P. Fisher, right? So Lawyer Bradley, Judge Fisher. I could see it, since it had to do with the assassination of Abraham Lincoln, that the Judge Fisher probably did cheat and probably did just kind of throw a bunch of little insults, to the side. Not meaning to be, but Judge George P. Fisher was trying to get the conviction, whereas the lawyer for Surratt, who's Lawyer Joseph H. Bradley, eventually at the end lost his temper and then just starts cussing George Fisher out. And then George Fisher says, well, you think you could talk to me, the judge, that way? You'll never work in this courtroom again. You mean this town? No, just this courtroom. You mean the entire city, the state? No, just this courtroom. And so it's interesting also, too, because Mireles is the first one, and then the lawyer is the second one. So Judge Raymond Mireles versus Public Defender Howard Waco. And then it's the opposite. In Bradley, it's Lawyer Joseph H. Bradley versus Judge George P. Fisher. John H. Surratt Jr. was the defendant in a 61-day trial. 8 members of the petite jury voted not guilty and 4 voted guilty. No unanimous verdict was reached. So because of a hung jury, John H. Surratt Jr. walked away a free man for the rest of his life. John H. Surratt Jr. was never tried again. due to the statute of limitations of murder being 2 years. 2 years? Statute of limitations to murder? The assassination of a president? The statute of limitations, man, it's been 2 years. So, even if he was a part of it, well, it's been 2 years. What can we do at this point? John H. Surratt Jr. is eventually going to get married. He's going to have 7 kids, and he's going to die an old man at 72 years of age. Now, John H. Surratt Jr. had maintained his innocence in the assassination plot. On a guy named Wakeman, John H. Surratt Jr. said that a murderer is one thing, but a person who perjures an innocent man is a double murderer. John H. Surratt Jr. also quoted a Confederate when the abrupt end to the Civil War had happened. Damn the thing, it didn't even flicker. It just went right out. Another area of law where a judge doesn't have immunity from a Section 1983 suit comes from Forrester v. White, 1988. In Forrester v. White, 1988, it instructs us that a judge cannot fire a probation officer because of his or her gender. Judge Howard Lee White had fired Cynthia A. Forrester. The 7th Circuit Court of Appeals said that judges are shielded from prosecution with a 42 U.S. 1983 claim, but they aren't shielded from other lawsuits and trials in general. The U.S. Supreme Court reversed and said that, yeah, Judge Howard Lee White, by firing his probation officer for being a woman, and I heard that there was sexual harassment too, he had acted as an administrator and was therefore operating outside of his judicial capacity, therefore making him open to a Section 1983 suit. That's incredible. That's incredible. So in 1988, people are going to say judges have, virtual absolute immunity, but they're not allowed to fire the probation officer. You can do what you want if it's a judicial act. Well, I fired the probation officer. That's not a judicial act. That's administrative. That's kind of a dumb distinction. How good were the lawyers of Cynthia A. Forrester? Cynthia A. Forrester must have had some good-ass lawyers. Truly judicial acts, according to Forrester v. White, 1988. Truly judicial acts are supposed to be distinguished from administration and legislation and executive functions. Judges have long enjoyed absolute immunity from liability and damages for their judicial or adjudicatory acts, primarily in order to protect judicial independence by insulating judges from vexatious actions by disgruntled litigants. Truly judicial acts, however, must be distinguished from the administrative, legislative, or executive functions that judges may occasionally be assigned by law to perform. It is the nature of the function performed, adjudication, rather than the identity of the actor who performed it, a judge, that determines whether absolute immunity attaches to the act. Forrester, 1988. Cynthia Forrester won $82,000 in compensatory damages. The Stump v. Sparkman, 1978 case grants judges immunity as well. And Stump v. Sparkman, 1978, is one of the worst goddamn decisions. It's as bad as Chaplinsky or Dred Scott or Plessy. In 1971, Judge Harold D. Stump approved a mother's petition to sterilize her daughter after the mother alleged that her daughter was somewhat retarded and that she was fraternizing with older youth or young men. And the mother wanted to prevent the daughter from getting pregnant, i.e. to prevent unfortunate circumstances. The petition that Judge Stump signed granted the doctors immunity as well. The petition in order was never formally filed. Linda K. Sparkman, they didn't even file the damn thing. Linda K. Sparkman, the daughter, the victim, she passed all of her classes. She never failed a grade. She was never held back. But her damn mother said that she's fraternizing with a bunch of older youth and young men. And we need to do something in order to prevent unfortunate circumstances, wink wink if you know what I mean, to prevent her from getting pregnant. And oh yeah, by the way, she's somewhat not all there, mentally or physically incapacitated. She used the R word, which we should not be using. That's her own damn mother. So her mother goes to Harold D. Stump. Her mother's Ora McFarland, the piece of shit. So Ora McFarland goes to the piece of shit Harold D. Stump and say, hey, Judge, can you go ahead and sterilize and tie the tubes of my daughter? Is that all right with you, Harold D. Stump? And Harold D. Stump says, yeah, that's cool. I'll sign it, but I'm just going to sign, not my name, I'm just going to sign the court, and I'm not going to actually formally file it. I'm going to do all this extra dumb shit because I know what I'm doing is fucking wrong. Linda K. Sparkman was never informed of the sterilization decision, nor was a hearing ever held. They never gave her notice. No hearing was held. No trial. There was nothing to appeal from. When Ora McFarland, the mother, took her 15-year-old daughter, Linda K. Sparkman, to the hospital, well, the piece of shit, Ora McFarland, lied about the sterilization. She just told Linda K. that the doctors were just going to take Linda K. Sparkman's appendix out. So, not only does she fucking lie to the judge to get the petition passed, the fucking judge signs off on the petition. On the day of the goddamn sterilization, the tying of the tubes, on the day of the sterilization, she tells her that she's just getting her appendix cut out. It almost seems like she's just guilty of believing that her mother's an honest person. She's just guilty. Sparkman, Linda K. Sparkman, was guilty of believing that Ora McFarland had her best interest in mind, which she clearly did not. When Linda K. Sparkman finally got married, she found out what had happened. Her and her new husband couldn't have children because of what Ora McFarland and Harold D. Stump and the doctors involved did. So when Harold D. Stump, the fucking shitty-ass judge, you got a shitty mother, shitty judge, and shitty doctors. Who's responsible for tying her tubes? All three of those people. Who's more responsible? You could debate the percentages. But this is such a fucking disgusting case. If the judge doesn't sign off on it, it doesn't happen. When the judge signed off on it, he's going to give immunity to the doctors as well. So the fucking mother, Ora McFarland, how come her mother has a different last name than Sparkman? Why does she have, I mean, who the hell is this Ora McFarland? Maybe it's your genetics. You know, you're sitting there saying all this about her. Sometimes when you point a finger at somebody, you got three fingers pointed at yourself. Ora McFarland, you're trying to get your 15-year-old daughter sterilized? Are you sure you're not fraternizing with a bunch of men? Are you sure you're not somewhat mentally incapacitated? Are you sure you're not mentally handicapped? So you got the shitty mother, Ora McFarland, ask Harold D. Stump to sign a petition. He signs it, gives the doctors immunity, and then the doctors fucking do it. Linda K. Sparkman then sued the mother, the judge, the hospital, and the doctors via 42 U.S. Section 1983. The U.S. 7th Circuit Court of Appeals said that Judge Stump didn't have any jurisdiction over the subject matter of sterilization, since there was no case law nor statute in Indiana law that gave him permission to do that to Linda K. Sparkman. All sterilization laws of Indiana had been repealed in 1974. So 1971 is when this case is going to pass. 3 years later, they're going to go ahead and just, well, no, 1978. So 1971 is when the petition had happened. And then 7 years later, she's going to get the Supreme Court decision. But in between that time, she got sterilized in 1971. The sterilization laws of Indiana was repealed in 1974. And then that Buck v. Bell case, 70,000, I heard 70,000 Americans got sterilized because of Buck v. Bell. God damn, the Supreme Court fucking sucks. Sometimes the Supreme Court don't just fucking, they didn't just make an error, they just fucking blow it. They just missed the fucking mark. Oh, you're supposed to establish justice, and they're like, I'm a judge. If I say that this judge is wrong, maybe somebody will look at my decision and say I'm wrong. Or maybe somebody will look at the fucking case and say you were wrong. You were wrong. The judge was wrong. Everybody who backs the fucking judge is wrong, you stupid ass motherfuckers. This is a Dred Scott decision, which means the dissent is the holding. The dissent is the holding. That's just natural law. That's just common sense. That's just rationality. That's logic. So, Stump, 1978, using the two-part test, the same two-part test that was in Mireles, 1991, the Stump decision, 1978, declared that Judge Stump had jurisdiction, since Indiana law had allowed judges to rule over all cases at law and in equity, and that while in error, Stump was performing the function of a judge. Later on, Linda K. Sparkman is going to change her name to Jamie Renee Coleman, Because of course she would. Why the fuck does she want all this publicity? People's going to be asking her about all this fucking bullshit that had happened to her. She wanted to goddamn have children. So in the time to kill, what happened? You just had that daughter who got raped, but she got raped so bad that she couldn't have kids ever again. That's what the fuck these assholes did to Linda K. Sparkman. That's what Ora McFarland did. It's what Harold D. Stump, the doctors, the hospital, and anybody else that was involved. The fucking clerks, the bailiff. Nobody else was paying attention. Nobody else was watching this shit. Where was her husband at? Where's the father at? Did you not inform the father either? Now, that's not the only terrible fucking Dred Scott decision. So let's recall what that one was. That was Stump v. Sparkman, 1978. All judges have immunity. No, they don't. No, they don't. If you fucking reference Stump v. Sparkman, then anybody who read that decision, you should slam the fuck out of that person. Oh, you referenced Stump v. Sparkman? You know what happened in Stump v. Sparkman? You piece of fucking shit. You're going to say that judges deserve immunity for that shit? If the judge didn't sign off, then it wouldn't have fucking happened. If the doctors didn't do it, it wouldn't have happened. If the mother didn't put the petition forward, it wouldn't have fucking happened. He didn't do a hearing. He didn't do a notice. He filed it improperly. That motherfucker did it illegally. He did it illegally, and he fucking knew it. That's why he did it the way that he did it. He also didn't sign his name. He signed it as the fucking court, as if your name is the court. Yeah, DeKalb County something. Well, DeKalb County judge, there you go. I signed it. Well, that's not your name, judge. I know, I'm a little sneaky sneak. Oh, you little sneaky sneak, creepy creep, criminal motherfucker. Another Dred Scott, Plessy v. Ferguson, Chaplinsky decision is DeShaney v. Winnebago, 1989. Oh my God, DeShaney v. Winnebago. Again, if somebody says, hey, according to DeShaney v. Winnebago, me as the judge can do whatever the hell I please. According to the DeShaney decision, yeah, okay, well, let's hear what the DeShaney v. Winnebago decision is. 1989. So you have a divorce that happens, and 1-year-old Joshua DeShaney is put into his father's custody. A cop and child services and doctors all witnessed the abuse. A cop, child services, doctors. Here's from DeShaney itself, 1989. 3 days later, the county convened an ad hoc child protection team consisting of a pediatrician, a psychologist, a police detective, the county's lawyer, several DSS caseworkers, and various hospital personnel to consider Joshua's situation. A pediatrician, psychologist, police detective. Oh, I guess he wasn't doing his fucking investigation work at that point. The county's lawyer, several DSS caseworkers, and various hospital personnel. So you have what? 9 goddamn government of fucking officials were sitting there considering Joshua's situation. So you had this child protection team consisting of about 9 or so, and at this meeting the team decided that there was insufficient evidence of child abuse to retain Joshua DeShaney in the custody of the court. Well, he only beat you a little bit this time. So the team, the child protection team, went ahead and recommended several measures to protect Joshua DeShaney, including enrolling him in a preschool program, providing his father with certain counseling services, and encouraging his father's girlfriend to move out of the home. Randy DeShaney entered into the voluntary agreement with DSS in which he promised to cooperate with them in accomplishing these goals. So the motherfucker signs the damn thing. Randy DeShaney, the fucking piece of shit, child abusing father, he's going to hit Joshua DeShaney so bad, it's going to beat him into mental, this is a, terrible word, but the other word doesn't really capture it, but I'll say the other word, mentally, disability, make him just completely gone. He's not there anymore. They use the R word, mental R word, profoundly R word. So they're going to beat him until he's not there anymore. He doesn't die, but he's not there anymore. He's shaking all the time. He has no cognition. They fucked him up. Randy DeShaney kept hitting Joshua DeShaney over and over again in his body and in his head over and over again. 1,000 fucking times, 5,000 times, who the fuck knows? Clearly he had some fucking issues. Wyoming's child services witnessed more abuse in the 7 month-to-month visits they conducted after the child protection team had convened. So child services does these month-to-month checkups, And they see that the abuse is still happening. You had the cop, the original cop. You had the fucking detective. You had the lawyer, psychologist, pediatrician. You had several DSS, Department of Social Services, caseworkers, and various hospital personnel. A nurse or two, a clerk. 7 month-to-month visits they conducted after the child protection team had convened. Joshua DeShaney wasn't enrolled in the preschool like Randy had fucking agreed to, and then Randy DeShaney's girlfriend still lived there. Randy DeShaney wasn't complying with the protection team's improvements. Eventually, 4-year-old Joshua DeShaney is going to be beat into mental incapacitation. They're going to beat him to where he cannot be a regular person anymore. They're going to beat him to where there is no mental cognition. He can't stand upright. I don't know if he's going to be able to wipe himself or put on shoes. He's just going to be shaking all the time. And he's going to just be shaking all the time until 20 or 30-something years of age. And then he's going to die. So in a way, he ended his life. And the little bit of life that he had on this planet, he severely restricted it. Fucking shit. Fucking shit. Joshua's mother, who's a good woman, at least afterwards, sues Winnebago County, the DSS, and the employees of the DSS. Now, apparently government employees, including police officers, are under no obligation whatsoever to protect the public. Your Honor, I saw the child abuse and I ignored it, and I didn't give a damn. That's cool, right? You got immunity, I got immunity. We all get immunity here. So the government has no obligation to protect us? Police officers have no obligation to protect us? What a stupid-ass decision. DeShaney v. Winnebago. This is Chief Justice Rehnquist. Of course, fucking Rehnquist. He writes for the 6-3 majority. But nothing in the language of the Due Process Clause itself requires the state to protect the life, liberty, and property of its citizens against invasion by private actors. Private actors? Winnebago County isn't a private actor. Private actor, the fucking county's lawyer, the police detective. Private actor. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. It forbids the state itself to deprive individuals of life, liberty, or property without the due process of law. But its language cannot fairly be extended to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means. Nor does history support such an expansive reading of the constitutional text. DeShaney, 1989. Great decision, Rehnquist. You piece of fucking garbage. You fucking piece of goddamn Caucasian trash. So everybody gets life, liberty, and property. You can't have life, liberty, and property taken without everybody gets equal protection of the laws. Everybody gets the same immunities or privileges. And everybody gets due process of law before your life, liberty, or property can be taken away from you. Unless it's Randy, unless it's a piece of shit child abuser father, unless it's a fucking cop and pediatrician and a bunch of fucking social workers that got their heads up their asses and don't know right from wrong. Justice Harry Blackman dissents. Poor Joshua, victim of repeated attacks by an irresponsible, bullying, cowardly, and intemperate father, and abandoned by respondents who placed him in a dangerous predicament and who knew or learned what was going on and yet did essentially nothing except, as the court revealingly observes, ante at 489 U.S. 193 dutifully recorded these incidents in their files. Oh, okay, the cop wrote a fucking report, the social services, the pediatrician, the fucking lawyers, the goddamn cops. They at least wrote about the child abuse and put it in the file. Isn't that good enough? I filed a report. I'm not going to press charges against Randy. Well, my mom and daddy they were abusive to me and they were awesome. I can't go after Randy. Yeah, and you let fucking Joshua DeShaney got beat into, he could have fucking cured cancer. He could have done so many fucking great things. But instead you motherfuckers took his life away when he was 4 years of age. You took away his life. And without life, he doesn't have mental cognition. What is he, 1% there? So he just got one eyeball open and the rest of him isn't open? So he has the liberty to look up and look down and look to side and that's it? So much freedom, goddamn. I'm so glad we went to the Supreme Court for this decision. It's a sad commentary. It is a sad commentary upon American life and constitutional principles, so full of latent patriotic fervor and proud proclamations about liberty and justice for all, that this child, Joshua DeShaney, now is assigned to live out the remainder of his life profoundly, R word, profoundly without mental cognition, mentally handicapped, almost to the point of no return. Joshua and his mother, as petitioners here, deserve, but now are denied by this court the opportunity to have the facts of their case considered in the light of the constitutional protection that 42 U.S.C. Section 1983 is meant to provide. So thank you, Harry Blackman. When Harry Blackman died, they read this as a eulogy at his funeral. DeShaney, 1989. Randy DeShaney did wrong, but it was a trial judge who had awarded Randy DeShaney in the first place with the 1-year-old Joshua. So trial judge went ahead and made the fucked up decision, and then the district court, the appeals court, I don't know their decisions. Sometimes they reverse them. But the Supreme Court ultimately is going to make the supreme fucking error and say that not even a little child in America has the right to life, liberty, and the pursuit of happiness. You don't have a right to petition, Joshua. Poor little baby Joshua. You don't have a right to petition. You don't have a right to speak. You don't have a right to an indictment by a grand jury, Joshua. Joshua, who the hell do you think you are, Joshua? So, conclusion. U.S. Grant had his carriage impounded, and he had to pay a speeding fine while he was president. Who has absolute immunity in a country such as ours? We got the three branches of government. Immunity is nowhere in the Constitution. We got elections, we got a Constitution, we got a Bill of Rights. Power corrupts, and absolute power corrupts absolutely. The king is not the law. The Rex is not the Lex. The Lex is the Rex. The law is king. We're a nation of laws, not a nation of men and women. Who is allowed to beat somebody else until they turn mentally incapacitated? Nobody can. If Joshua DeShaney was to smack Randy around until he had no mental cognition, you think any of these judges or cops or DSS, you think the Supreme Court would have been like, wait a second, that's like the Menendez brothers. We don't want that to happen. It's okay for the Menendez brothers to be abused, but we don't want them abusing their abusers. That's not justice. Yes, it is. Eye for an eye, stripe for a stripe, a hand for a hand, a foot for a foot. That would be fucking justice. So even if the president has to pay a speeding fine, he's flying by in his carriage, his horse in his carriage, he's flying by and a black police officer is going to pull him over and give him a ticket and have his carriage impounded. U.S. Grant gave $20 for his bail and then never came to court. So that's contempt of court, right? He just gave him the bail and said, adios, motherfuckers. But he did enough to say that even the president has to obey the speeding laws. You can't drive 100 miles an hour. You can't fly by with your fucking horses and carriage like that, Mr. President. And then the police officer was super nice about it. He was like, I've warned you twice, Mr. President. You know, why are you driving so damn fast? People are jumping out of the way. Everybody's like, oh shit, here comes Ulysses S. Grant. Oh shit. So if the president doesn't get absolute immunity, why the fuck would a legislator or a goddamn judge? The fucking president don't even get immunity. A corrupt and malicious judge should not be immune from prosecution or consequences of punishment. The only person who ought to get absolute immunity would be an innocent person. An innocent person should be immune from the courts, immune from arrest, immune from wrongful arrest, wrongful convictions, wrongful imprisonment. Absolute immunity is so fucking un-American, it's not even funny. It's not even funny. Don't even tell me it's funny, because it's not. An innocent person should be immune. Being cautious, being, you know, I guess conservative, is that what the word I want to use here? Being classical, conservative with my classical liberalism, I don't believe in immunity for any person in any official capacity whatsoever. Strict constructionism, originalism, I don't see the word immunity anywhere in the goddamn U.S. Constitution. Where's it at? I don't see the word abortion either. I also don't see the word immunity. So we're going to what? Just read immunity into the Constitution when it's not even there? Now I'm going to be cautious. And my classical liberalism, I'm going to be super conservative about. So I don't see any immunity for anybody. In the rule of law says everybody has to obey the laws. Everybody's got to obey the laws. Who the fuck gets absolute immunity? Nobody does. The rule of law dictates that everybody lives under the law. Since we're a nation of laws, now I'd prefer to say maximum, maybe a maximum immunity or something, but not absolute. 100% absolute. I get to do whatever the hell I want to do. There's this one case where the goddamn fucking judge stole millions of dollars for his wife's law firm. He's allowed to do that? He's a fucking judge. He can walk out of the courtroom, commit crimes, and then write an order, and then he's immune. He's immune. As long as they do official duties, right? So you committed the crime, not official, but then he wrote the order, and he made himself immune. That's cool. That's all right. Everybody's cool with that, right? Thou shalt not steal. Thou shalt not murder. Thou shalt not bear false witness has been good law for 3,500 years. I am the law of Moses. So the rule of law dictates that everybody lives under the law. We're a nation of laws, not of men or women. So I prefer to say maximum if we're going to say anything, but absolute, get the fuck out of here. For 1983 claims, because of the wording of the 1983 claim itself, a judge wouldn't fit the wording of a 1983 claim. While judges are a person under a color of law who are most in the position to deny constitutional freedoms, rights, privileges, or immunities, 42 U.S. Section 1983 says that judicial officers, for an act or omission committed in the judge's judicial capacity, are exempt from the statute. Now, there's a lot of loopholes there. Injunctive relief is also exempted as a judicial remedy unless a declaratory decree was violated or declaratory relief was unavailable. That's because of that 1996 fucking law. Thanks a lot, Clinton and Biden. The declaratory decree is a type of court action in which a plaintiff seeks a judgment from a court declaring the rights, duties, or obligations of one or more parties. The purpose of a declaratory relief action is to obtain clarity on a legal issue before any harm or damage has occurred. This can be done either as a separate lawsuit or as part of another legal action. In the local rules of the U.S. District Court in Denver, a judicial officer specifically is defined as a district judge, a magistrate judge, or a circuit judge sitting by assignment. So can you sue a district judge, magistrate judge, or circuit court judge? Not if they're acting within their, what did it say exactly? Judicial officers, for an act or omission, so for doing something or not doing something, that's committed in the judge's judicial capacity, are exempt from the statute. So if a district judge, a magistrate judge, or a circuit court judge does something within their judicial capacity, then they just strict construction. Read the law as it is. They added this shit in 1996. This immunity hadn't been there until the fucking goddamn Clintons and Bidens. Bunch of conservative right-wing fucking bastards. A bunch of Rush Limbaugh conservative liberal-hating pieces of shit. In the local rules of the U.S. District Court in Denver, a judicial officer is defined as a district judge, magistrate judge, or circuit judge sitting by assignment. I would end it right there. That's it. Construction, strict construction. So we're going to go ahead and exempt a judge as long as they're within their capacity, as long as they're within their jurisdiction. And that includes a magistrate judge, a district judge, or a circuit court judge sitting by assignment. I think that's a good definition of a judge and a judicial officer. If a judge isn't a judicial officer, then who the hell would be? So, yeah, magistrate, judge, or district judge, or circuit court judge. Now, it further sucks because if anybody thinks that they're absolutely immune, then there's going to be no consequences for them being malicious and corrupt. That's the rule. However, the rule is the rule. There's always exceptions to the rule. A bully will continue to be a bully until they're stopped. A bully will continue to bully until they are stopped. Bullies have to be made to stop. It said that the judge are judged by appellate courts. And so, therefore, every rule, there's exceptions, such as that declaratory decree, or for injunctions. Injunctions are a lesser thing than suing for damages. But technically, they're saying that judges have to deal with the appeals court and their own Supreme Court. So there's already a process for them to, their fucked up decisions to be rectified. And it sucks. You have Scalia that said, You can concede the point, but do so ostentatiously. So that's what I did here. Judges are most in the position of robbing we the people of our civil liberties, our rights, our freedoms, our privileges, our immunities. Judges can take away our seventh right, their 7th Amendment, 4th Amendment, 5th Amendment, 6th Amendment, 8th Amendment, 1st, 2nd, 3rd Amendment. Hell, all the amendments 1 through 8, as well as the civil rights before the amendments in the body of the Constitution, and all the amendments after the 8th Amendment, up to 27, from we the people, by a judge, duly elected or appointed. Now, there's a lot of shit that had happened, and I don't know if I got time to say all the shit that had happened, but we'll just go ahead and conclude this, because I have all the fucking bullshit that had happened, and there was a lot of shit a fucking judge in Colorado did to me. We Americans overthrew the king's government. No person is king in America, not even the president. I don't know precisely what I think about qualified or absolute immunity, but for the sake of caution, I'm going to reject it outright. In spite of the trial judge being in the position to strip my constitutional rights away from me the most, from both America and Colorado's constitutions because of Section 1983 strictly constructed, I do not believe I can bring a suit against judges nor magistrates under Section 1983. Now let's sally forth against the pestiferous. I'm going to see if we got more time to just mention some of the fucking bullshit. This is 36, so no. So, okay, that's a little bit about judicial immunity. Even though I concede the point, there are loopholes, and I'm going to get to the exceptions later on.